Hi, I'm Gretchen Sable, and I'm the moderator of today's interview. This is the first in a series of interviews aimed at learning about the roles of Minnesota's constitutional officer. Our goal in today's event is to set a firm baseline of understanding about the authorities granted to three of our constitutional officers: the Attorney General, the State Auditor, and the Secretary of State. So, just what is the State Auditor supposed to be auditing? What's the role of the Attorney General in overseeing cases in county courts? Does the Secretary of State have the discretion to require photo ID for voting? We'll cover all these topics and more in this session. To get the answers, I will have the privilege today of interviewing Jason Marasam, JD, from the Hamlin Mitchell College of Law, where he teaches constitutional law, administrative law, and civil procedure. Jason's research focuses on voting rights, election law, and administrative law. He's a 2008 graduate of the Harvard Law School and former editor of the Harvard Law Review. In 2021, Minnesota Lawyer honored him as Attorney of the Year for his work on the 2020 election, where he was an assistant Attorney General for the state of Minnesota. In 2022, Minnesota Lawyer honored him as Attorney of the Year for his work on the constitutionality of Minnesota's pardon system. This event is part of a series we're planning with LWV Minnesota on our constitutional officers. We're starting with Professor Marasam providing us background on what our Constitution says about the roles of these officers to clarify what became pretty confusing in the last election. The next meeting in this series will be LWABC's Jody Anderson interviewing Keith Ellison on January 18th. We're also making plans to seek interviews later this winter with the State Auditor Julie Blaha and the Secretary of State Steve Simon. The League of Women Voters is a nonpartisan political grassroots network and a membership organization that believes in the freedom to vote is a nonpartisan issue. For more than a century, League has worked to empower voters and defend democracy. This session is part of our mission of helping voters be informed on important issues and how their government works. So we're going to start off with some general questions, but maybe Jason, you want to give a little statement first or anything before we get rolling?
I can be brief. So the background that I come to this with is that I was an assistant attorney general in the Minnesota Attorney General's office for 6 years, where I did work on constitutional administrative law and other cases for the state of Minnesota, and also represented the Secretary of State's office in a bunch of cases. And so that's sort of the general background that I came to this with, and then also poked around the Minnesota statutes to try to fill in some gaps in my knowledge that I didn't have from just my practice experience. But as Gretchen said, I'm now a professor at Mitchell Hamlin.
Okay, good. So can you please outline the general responsibilities of these three officers, Secretary of State, State Auditor, and Attorney General? And what we're looking at here is what's in the Constitution, so that really forms the baseline.
Yeah, so the Constitution is pretty general when it comes to these offices, as it is with a lot of things. You have to start with Article 5 that establishes that the executive department consists of a governor, lieutenant governor, secretary of state, auditor, and attorney general who are chosen by the electors of the state. Now, that does make the state constitution different than, say, the federal one that doesn't have all these separate elected executive offices. But when it comes to the actual duties of these different officers, there's some gems on impeachment for your terms, salaries set by the legislature, and a few specific provisions. For example, talking about the Secretary of State, enacted laws are deposited with the Secretary's office. Election returns are made to the Secretary's office. And a couple specific provisions, but it doesn't go into great detail about what the responsibilities of those officers are.
Okay, thanks. So then there must have been additional duties put on these offices through legislation, right? The laws have been directing them to do different kinds of things, or maybe even the courts have made decisions, right?
That's right. So start with the Attorney General. The Attorney General is an old office. I mean, they trace it back, you can go back to pretty far back in English history and see the role of the Attorney General as representing the sovereign. So the Supreme Court, Minnesota Supreme Court, has said the Attorney General has some inherent authority that doesn't necessarily need to be spelled out, and that is to represent the state in litigation and to have discretion over that litigation, how to defend, whether to appeal. Those kinds of things are inherent in the office of the Attorney General. But for all three offices, most of the duties do come from statute. I can tick off some of the major ones for the offices quickly. So starting with the Attorney General, Statute 8.01 is key. It says the Attorney General appears for the state in all causes where the state is a direct interest and where the Attorney General thinks it's required. So the Attorney General has a duty in some sense to defend the state when it's sued. There on criminal stuff. Now this came up a lot in the election. What's the Attorney General's role in criminal prosecutions? What 8.01 says, Minnesota Statutes 8.01, is that the Attorney General can prosecute really in two instances. If the county attorney, who in Minnesota's system, the county attorneys are the lead prosecutors of prosecutorial discretion. If the county attorney requests that the Attorney General come in and help out prosecute, the Attorney General has discretion to accept that request. Or if the governor requests the Attorney General in writing to prosecute a case, the Attorney General has to do it. Other than that, those direct requests, prosecution is done by the county attorneys in their offices. The Minnesota Attorney General also has another key area by statute is broad consumer protection authority. And that would be not defensive, but offensive. That the Attorney General can bring under statute 8.31 and others unfair, unlawful business or trade practice cases to get injunctions and other remedies to sort of stop those unfair practices and protect consumers. There's other common law powers too. It has the common law parens patria authority to litigate stuff on behalf of the state as a whole. We saw that authority invoked during COVID to enforce some of the governor's emergency orders in order to protect the public. It was under that common law parens patria authority mostly. So pivoting to the Secretary of State, what are the statutes set out for the Secretary of State? Well, thinking about elections, the Secretary's office, because we do have, I think it's 87 counties in Minnesota, and the Secretary's office provides a real centralization and coordination function. So for example, voter registration. The Secretary's office maintains a centralized voter registration system, a master list of all registered voters. If you want to run for office, you file a petition with the Secretary's office. And generally, election-related forms, ballots, pamphlets, posters that you see in precincts about what the language is for voting and getting voter assistance, all that comes from the Secretary's office. It's sort of a centralized place that then goes out to the local election officials. The Secretary also has rulemaking authority to sort of fill in the gaps in some of the election laws and be more specific. A key role here is canvassing election returns. The Secretary is the chair of sort of the state canvassing authority. When you meet to the state certifies, these are the final results. This is it. That's the Secretary's job. And also related to elections, if an election law is invalidated by a court, enjoined from being used, the Secretary is the one who has the authority to sort of adopt the alternative procedures ordered by the court and implement them. That's statute 204B.47. Secretary also has some authority related to businesses, particularly with registering. This chapter 5 is a whole bunch of stuff. If you're a business entity and you want to operate in Minnesota, you register with the Secretary's office. Now, to the state auditor, in some ways, it's a bit of a misnomer because people see state auditor, they must be talking about state functions. By statute, the primary function of the state auditor is to perform audits of political subdivisions. So local government, that's the primary function. The state auditor is auditing local government financial statements, reviewing documents, data, reports, complaints to the office, and preparing reports to the legislature on the local government compliance with the different financial rules. And they can investigate that stuff. But sometimes there's a confusion between the state auditor and the legislative auditor. So the state auditor is typically auditing the local government functions. The legislative auditor has authority to go audit the state agencies that are directly funded by the legislature. So if the legislature wants to look into something, say that the Department of Human Services is doing, they can task the legislative auditor to go and do that. That's separate than the state auditor, who's typically going to be auditing the local governments and political subdivisions.
So thanks. I have a question. Are these offices intended to operate independently of the governor and the legislature? You did point out that the governor can direct the AG to take up prosecutions. So do these other officers act independently, or are they part of a team?
Sort of both. At a high level, they're independent. They are separate constitutional officers that are elected separately by the people of Minnesota with their own core constitutional functions and then statutory functions that are filled in. But there are definitely relationships there. There's some by law. So, for example, the instance of the governor can direct the attorney general to take up a prosecution. Some of it, and there are also, all of these officers are together in what's called the executive council that has certain functions to work on. And there's also just relationships of working together. So think about the attorney general. That office provides the attorneys for the state. So anytime the state agency gets sued, the governor gets sued, and any of his appointees, running the state agencies get sued, it's the attorney general's office that's going to provide that defense. So there needs to be at least some working relationship. And the healthier that relationship is, you can see a stronger work dynamic between the governor's office and the governor's appointees running the agencies and the AG's office. Sometimes you'll see if trust is broken down or a particular case warrants it, the governor's office will decide to hire outside counsel instead of using the attorney general's office. But for the most part, they're working together a lot. The COVID stuff's a good example. I mean, you needed that teamwork for the governor to issue the order saying, COVID first comes out and there's restrictions on businesses and how, when you can be operating. You need that attorney general force to give teeth to those orders, to bring those enforcement suits in order to make sure that those are being followed. And that required teamwork between the governor's office and the attorney general's office.
Thanks. So you said the Constitution's kind of vague in its requirements, but there is legislation that changes the duties of these offices, right? And then the courts would weigh in if that legislation doesn't meet the Constitution, I assume? That's right.
So most of the details of the authorities coming from legislation that could be changed. But what the Minnesota Supreme Court has said for these constitutional officers, the legislature can't eliminate that office or transfer its inherent or core functions. So whatever these inherent or core functions are, which would be up for litigation and definition through court, they got to stay with that office. So the legislature can come along and clip some wings, trim some of the details, shift some authority here and there, but can't get rid of the office or diminish their inherent or core functions.
Thanks. So I assume then too, there's also checks and balances to ensure that the officers act in the best interest of the citizens of Minnesota, right?
Yeah, for sure. There are a few. I mean, most immediately, these officers are subject to direct election. I mean, they're not appointees. So you just have, that electoral accountability directly from the voters. There's a recall function too, that's not often used, but it's the same idea of accountability through to the people through elections. There's legislative oversight. Even though, say the Attorney General's office is not a state agency in the way that the Department of Human Services, where it's run by an appointee commissioner appointed by the governor, their budget is set by the legislature. That's huge. So the Attorney General gets up there and the other offices and say, here's my request for how much money I need. Here's what I want to do with that money. And the legislature says, you're not getting all of it, or we're giving all of you it. Give whatever that is. That is a huge check. Yeah. On what the office does. And there is judicial oversight too. I mean, just the basic idea that these offices need, whatever they do, they need authority to act, whether that authority is the Constitution or the statutory authority. And if they don't have that authority, it can be challenged. So we do see sort of direct accountability and then legislative and judicial oversight as well.
So the next series of questions I have here regard to Secretary of State. And I want to start off kind of in an area that we as League of Women Voters don't even think of the Secretary of State in establishing and running businesses. So how are these duties different from other state offices like the Department of Commerce or Economic Development, which are headed by a governor's appointee? And how much discretion does the Secretary of State have in his business administration functions?
Yeah, so when the business administration, it's much more of a ministerial centralization function for the secretary's office. If you want to incorporate as a business, you'd file your papers with the secretary's office, or make any amendments to whatever paperwork you already have submitted. And that is going to be reviewed and approved and filed with the secretary's office as a centralized sort of clearinghouse to have that information. Universal Commercial Code requires collateral in certain cases, and you need a centralized office for that to go, and it's the secretary's office. They also, notary, you want to be a notary public, centralized place, it's the secretary's office. But it's not a regulatory office. And that's the key distinction between the Department of Commerce, which can have some regulatory authority and go more in depth with the rules with enforcement behind it, versus the secretary's office is more of a centralized filing place when it comes to the businesses.
Well, thanks. That helps. So we're going to look now at election law and the role of the Secretary of State. What election policies are required by the Constitution, by legislation, so we understand more the basis for our election law?
Yeah, so the Constitution says a lot about, well, it has a few sentences there on voter eligibility. It establishes a baseline for who's eligible to vote in Minnesota. You got to be 18, a U.S. citizen, lived in the precinct for 30 days. If you have a felony conviction, you lose the right to vote until you're restored to civil rights. And if you're not competent, you lose the right to vote. That's all in the Constitution, voter eligibility. The actual mechanics of the election is all through legislation. So registering to vote, when do you have to do that? How do you have to do that? Statute. That's done through statute. Absentee and mail voting, what's the process? Statute. You know, what the rules are for operating the precinct. All those details are coming through statute.
So are there common voting practices that are at the discretion of the Secretary of State?
Really, no. There is discretion in the office on certain things of, like, they do training a lot, for example. They'll train the election law judges, and they're in charge of running that training. And obviously there's discretion in how you're training. There's not discretion in what the laws are that you're teaching them, but how you put it together or something like that, there's maybe some wiggle room. But in terms of what the policies are, I'll give you another example of what I think a key one where there is discretion. The Secretary of State has authority to do outreach to encourage voter participation. So how does the Secretary use that authority? That's different than a ministerial job of, I'm maintaining a list of registered voters, or here are the actual returns. That's a real ministerial clerical job. There's some discretion of, okay, how are we going to encourage voter participation this election? And in that way, the Secretary has some discretion.
In my intro here, I said that we were going to talk about photo ID. Could the Secretary of State decide that we need to have photo ID?
No, that's not the law of the state, and the Secretary doesn't have the discretion to just implement or require that. And even when their elections are run, they're mostly run at the county level. So the Secretary's main function is really a coordinating function. It's not like the Secretary has direct authority to say, hey, county, do this. The laws are all set, the rules are set, and the Secretary is helping facilitate how that election is going to be administered.
So that leads into a question here. So who would enforce violations of voting laws when people vote twice, say,
Yeah.
or felons that vote without the proper clearances?
That would fall under the way criminal law typically works, which would be the county attorney's office could prosecute for whatever legal violations, criminal violations happened in that county, in that jurisdiction. Also, in theory, if there was, say, a constitutional violation that a local election official was committing, in theory, the attorney general could bring that suit, or private parties could sue the local officials or the Secretary of State to protect their constitutional voting rights. And that's something that's interesting. Of, let's say you are, sometimes it's legal women voters. Let's say you're a plaintiff in a case trying to protect constitutional voting rights, and you're challenging a rule or a policy from Minnesota. The person that's typically sued is the Secretary of State. The Secretary of State is seen as that single official who you would sue to challenge the voting laws. Now, you have all the county officials out there who are the ones really implementing those laws on an on-the-ground basis. But practically speaking, it doesn't work from judicial administration to say you need to serve and sue every single local election official implementing this. The courts haven't really thought that was a good idea. So we've got the Secretary of State. That's the chief elections officer for our state. So if you want to challenge the constitutionality on its face or as applied of an election statute or rule, that's who you sue. And then it's up to the court to decide whether they want to issue an injunction. And it's seen as that injunction would apply statewide if the court would enter.
So that's clear then about voters doing things wrong. What about if a local government were to decide that they were going to administer elections differently because they know how they should do it?
Yeah, I think in in that case, we're say it really is a rogue local official or something like that, or officials that are implementing the rules in a discriminatory manner. And it's a particular official that's not applying it right. You could sue that county or that local official directly. Also, in theory, I think the attorney general could bring suit against the local officials in order to protect the rights of the state as a whole, although I think that would be pretty unusual. But most part, if there's a particular official that is not, say checking voter ID when it's not allowed or something like that, and you wanted to stop that practice, you could go, if it's a particular county that was doing that, you would sue that county if it had nothing to do with the actual rule itself coming down from the legislature or Secretary of State.
So then really we as citizens have responsibility to kind of watch and oversee elections to see that elections are handling correctly. And then it would be up to a group like League of Women Voters, say, to bring a lawsuit if there's problems observed.
That is an important part of public transparency in our election process, is having groups like League of Women Voters out there to make sure that the rules are implemented fairly. It's not enough that we have good access to the ballot rules. We also need those good access to the ballot rules to be implemented fairly. I saw a study some years back, it was for a different state. It was a state that also did not have voter ID law. And local election officials in certain precincts were still asking for voter ID. And they were more likely to ask for voter ID if the person had a Latino last name. Statistically, the analysis was crunched. Well, that's a problem. Not only was there they shouldn't have been asking for the ID at all, it was being done in a discriminatory way. That's not a problem with the statute itself. It's a problem with the implementation on the ground. And so you need people who are looking out for issues in implementation on the ground and willing to step up and make sure that it's implemented fairly.
Thanks a lot. So the last question on Secretary of State. So the Secretary of State's always made voting information in multiple languages available, but that's not required by law, right? It's completely a discretionary thing.
I believe the Secretary of State does have discretion when they come up with the different, like which different languages are there going to be, and the instructions when you have the posters and what languages is that going to be, and what exactly will the instruction be in. But there, in order to protect voting rights, that is an area where you could see a lawsuit or an injunction or a consent decree. I had a case a few years ago with the Secretary of State's office, and the secretary agreed, where part of the settlement was, here's the language, here's the text that you agree to use in the poster that goes up in the precinct, and here you agree to use these languages in order for the text to be accessible and usable by the range of voters that we have in Minnesota. So I don't believe it's set by statute, but it is something you could see come out of a court injunction or settlement or consent decree.
Well, good, thank you. Yeah, those of us that work as election judges, you have information available in many, many languages, and you hope anybody that comes in speaking those languages also has enough English to get through the process. So thank you. We're going to shift to looking at the state auditor now. So the state auditor is a role that not many people know a whole lot about. You said that they are mostly geared to overseeing the finances of local governments, which is very important. Do they have a role also in the oversight of nonprofits? So nonprofits are incorporated by the Secretary of State. They file tax records with the IRS. So does the state auditor have a role in any of this?
Well, I'll first start on this role of the state auditor with the caveat that between the Attorney General's office, where I worked for 6 years under 2 different administrations, and the Secretary of State's office, where I represented them in about maybe 10 different lawsuits, this is the one where I know the least. I did dig into the statutes to try to fill in the gaps of my knowledge. So just with that caveat, I'll answer your immediate question of, not that I know of, I couldn't see any basis in the law to go after, for the state auditor to go after the nonprofits. It's certainly not in the Constitution. And in digging through the statutes, it didn't jump out at me that was there as a statutory duty either.
Okay, well, thanks. So then what levels of government does the state auditor audit?
So this is clear in the statutes that it's locals. Political subdivisions is the language used in the auditor's main statute, that it is there, the state auditor is there to audit and help the finances with the political subdivisions, counties, cities, municipalities.
School districts as well?
Their school districts are mentioned in the statute in 6.49 to 0.51.
And also like soil and water conservation districts and other kinds of special purpose governments, the railroad authority and whatever.
I believe so. If you go to on the auditor's website, they have a list of all recent audits, and there's a section for special districts, is I believe how it's labeled, and there are audits that were done for these different special districts by the state auditor.
Okay. Does the state auditor look at the level of indebtedness of cities and counties? Do they get it? Are they just auditing it and giving a statement, or do they actually look at the financial health of these entities?
That's something I'll plead a bit of ignorance on. I think you might need to ask the state auditor that one. I couldn't find anything directly in the statute related directly to indebtedness, so I'm going to need to plead ignorance on that one.
Okay. And so you don't know, do you know about compliance then too? We'll be happy to talk to them about it. So
yeah, well, the auditor does have the authority to look for compliance problems. That is not these local governments in how they're tracking their finances, not complying with the different state laws. Now, let's say the auditor finds a problem. What's the auditor going to do? The main remedy seems to be that the auditor prepares these reports to the legislature. So it's sort of state legislative oversight. The auditor doesn't have some sort of special enforcement teeth to then sock it to the local government.
So they truly are auditors, just like an auditor that you would have in to check the books of your business or something.
That's right. That's right. And again, the political subdivisions.
Yeah.
When there's a concern about how the money's running through a state agency, that goes to the legislative auditor.
I know that if you go to the state auditor's website, they have lots and lots of data. You can look at very many different reports of the financial doings and comparisons of the different counties and cities and stuff. So it's pretty interesting stuff. Thank you about that. So let's take a little trip over to the Attorney General now. So the staff of the Attorney General represents state agencies in the enforcement of laws. You talked about that. How many AGs are there? And is that staffing sufficient to meet the agency's needs?
So I don't have the exact number. Might need to do a data practices request to figure that out. I believe it's somewhere around 130 attorneys these days.
Okay.
way down from where it used to be under Skip Humphrey, say. I'm sure the Attorney General would say that's not enough. I mean, that is one of the asks to the legislature is funding for more and different needs, depending on the priority. And I'll give some background here on how the numbers of in-house attorneys have fluctuated. Just if you zoom out, and this is sort of a background of two different ways of structuring an Attorney General's office that's neither good nor bad. They're different states use different models. One is a very big centralized office where the attorneys for almost the whole state are housed. So the individual agencies wouldn't have too many different attorneys. They would have a division within the Attorney General's office that's tasked with representing that agency. And the agencies themselves wouldn't really have in-house counsel. So that model is a very large Attorney General's office. The second model is a more slimmed down Attorney General's office, where the agencies themselves have a lot of in-house counsel devoted just to that agency. So Human Services would have a general counsel and a team of lawyers that work on just human services issues. And what the Attorney General would mainly do is the litigation piece. And when they get sued, they come in, but the sort of day-to-day lawyering advice would happen in-house. Different states do it different ways. One's not necessarily better than the other. Minnesota used to have that sort of large, I believe had nearly maybe 300 attorneys at the Attorney General's office. And at one point was sort of the largest law firm in the state, if you will. That's changed over before Keith Ellison, maybe under Mike Hatch around that time, where it started to slim down. And so you got fewer attorneys at the Attorney General's office, and the agencies themselves started to hire attorneys. So all the big agencies now have their own general counsel. The really big ones have multiple attorneys reporting to the general counsel, but even some of the smaller ones have at least a general counsel. Not all, but that's been the trend. So it's hard to say how many attorneys are there in the working for the state of Minnesota. There's been a shift where you used to have a few hundred just in the Attorney General's office, and now I say it might be 130. Those attorney positions didn't necessarily disappear. They just migrated in-house to the agencies.
Okay.
Still, the question of does the Attorney General have enough, that depends on the priorities and what the individual administration wants to do.
And again, that's based on funding from the legislature. So it's not like the Attorney General has a source of funds they could tap into outside of that.
Yes and no. So there is a big chunk of funds comes from the legislature. But because as the Attorney General provides legal services for the individual agencies, they bill those agencies at a subsidized rate, way less than the private law firms would pay. And depending on the individual contracts with the individual agencies, the agencies then transfer money, from their state pot of money to the Attorney General, and that can be a revenue stream.
Okay.
So, for example, if the Department of Corrections is sued and the Attorney General is representing them, there are billable hours that are sent, and the department then pays the Attorney General's office.
So, looking at the role of the Attorney General in prosecuting cases, there was a lot of talk about, there's a lot of concern that counties either pick up or don't pick up certain cases. And what you said at the beginning there was that the county can either request the Attorney General to get involved, or the governor can direct the Attorney General to get involved. But it sounds like the Attorney General doesn't really have a role in oversight of what the county attorneys do then. Is that correct?
That's correct. They're independent offices. And in practice, what I think happens, and again, I was in a civil division, didn't work directly in criminal, but what both the statute lays out and what you would see is the counties sometimes would request the Attorney General's help in prosecuting a case. As a practical matter, when would that happen? Well, the large attorney offices, Ramsey, Hennepin, Dakota, they pretty much will handle everything in-house. But you have small counties and outstate, and let's say they get a complicated homicide case that they might feel like they don't have the resources for. That's when they would go and ask the Attorney General's office for help. And then it'd be up to the Attorney General whether to provide that help or not, but typically would. The Attorney General has no legal authority to independently say, I am bringing this criminal prosecution against person X in this county. No independent authority to do that at all. The Attorney General has authority to implement consumer protection cases directly, but not the criminal cases.
Okay, well, thanks. Let's see. I'm reading all my questions here.
I will say one point that is
Yeah.
sort of related to this, the resources of attorneys. Say, I mean, what came up in the campaign of, well, the idea that maybe the Attorney General should still beef up the on-the-ground prosecutors in order to provide that help. That could be fine. That could work. But I don't think at the end of the day it would change all that much. You'd just be shifting the resources a bit from, how many prosecutors do we have in the counties versus how many do we have centralized state? So if all of a sudden the decision was made, the Attorney General's office should have a huge in-house division to handle these, I think you'd just see more counties hiring fewer prosecutors and asking the state to do it instead of the system we have now where the counties are the ones that start with the prosecutors. From my perspective, I don't think that would be a cure-all at all. You're just sort of shifting the level of government that has the bulk of the prosecutors.
Okay, so I just got one more question in this vein. You had talked about COVID enforcements. And so I know that there were some counties that said they wouldn't prosecute COVID violations and others that did. So how did all that work?
Well, interesting. Whether it would be for criminal, if anything were criminal, it would be up to the counties. But from my understanding was, say, a bar that refused to close in the early weeks. The Attorney General could bring an enforcement action seeking an injunction, in compliance with that under the common law authority of Parens Patria. Not a criminal case, but would be a civil case to enforce compliance with when the governor's orders were in effect.
Okay. Well, thanks. My last little set of questions here is about relationship of these offices to the governor. We talked about that at the beginning, that they're independent elected officials, but they need to have a good relationship. Apparently, they all serve on something called the Governor's Executive Council. And what does this group do?
So that's set up by statute. And yes, all the executives are in it together. They have a few jobs, like they can designate banks to be depositories for state funds. If there's a settlement that involves, a dispute between the state of Minnesota and the United States, say over federal and state lands, and that they'd be involved in approving that settlement or not. They also have some authority to respond to emergencies and disasters, to take necessary measures to prevent a disaster that threatens to destroy life or property. So there was, and I'm not an expert in how with COVID, how much the governor went through the executive council, but I know the executive council was involved early on, at least in some level, through the emergency powers. And they all sit on that and work together, hopefully, when it works well in the state interest, ideally.
Yeah. Okay, so also the Attorney General serves on the Board of Pardons along with the Governor, the Chief Justice of the Supreme Court. So what does that board, what level of pardons do they offer? They can't do federal.
Yeah, not federal, obviously, but if it's a state crime, which most are, they meet, and there's a statute that, so the Board of Pardons, it's created by the Constitution. The details are filled in by statute. They have to meet every so often. I can't remember how often. I think it might be quarterly. And they vote on pardon applications to pardon anyone who's been convicted of a state crime. By statute, you need a unanimous vote.
Oh, okay.
And that's one of the cases that I worked on recently. There was a challenge to the constitutionality of that unanimity requirement. Was pushing for a sort of governor +1 rule, like that instead of the governor, AG, and Chief Justice needing to affirmatively vote to pardon, you just need the governor +1 more. And the governor did push for legislation that would make that change that didn't get off the ground. And the Supreme Court, Minnesota Supreme Court, upheld the constitutionality of this. You need a unanimous vote by the three of them. There is some movement, and I don't know whether it ever gained traction or not, but movement for to amend the statute to make it a governor plus one rule, so that you wouldn't need all three voting for it. But as of now, you still need unanimous vote.
Do you know how many pardon applications they review in a year?
Gosh,
Hundreds?
It might be that many. I mean, they meet. I wouldn't say hundreds. Gosh, I would be guessing, but more than a few. I mean, I think in any time they meet, there could be a dozen in any meeting, maybe more. And obviously some maybe they talk about more than others, but they do meet, and they have a staff devoted to representing the board itself and helping with that administrative process.
That's interesting. So we hear a lot about nonprofits these days, and there's some high-level prosecutions going on right now. There's also a charities division in the Attorney General's office. Is that correct?
Yes.
And they do prosecutions or oversight, or what's their role?
Yeah, so it's in some ways tied up with the Consumer Protection Authority that the Attorney General has. So not necessarily criminal, but they can supervise, investigate corporations, and to bring proceedings to ensure compliance with different consumer protection laws. So, and also with charitable trusts, which we've seen. So the Attorney General has the statutory authority to institute proceedings to ensure compliance with state laws and state consumer protection and fiduciary duty stuff. To ensure a charitable trust is complying with all that, and the authority generally to go after corporations that might have consumer protection violations.
Okay, so we got some questions from the audience, if you're up for that.
Sure.
Can you see them in the chat, or do you want me to read them? I'll read them for the people anyhow, but it might be easier for you if you're reading along.
Okay, hold on. So I'll scroll up.
Okay. I was going to do the re-state auditor. Why are so many local government bodies able to opt out of having the state auditor's office performing the audits? I would assume that the intent was to have one office using common practices and principles performing audits as a form of oversight to ensure residents of the state that their counties, cities, and school districts are using correct financial practices.
Yeah, that's a good. I don't know the history about that one. I think you're right that the purpose of having a sort of uniform statewide system makes sense. Why would you? Why let the locals opt out? I don't know the politics of it. I don't know. I'd be curious whether it's the large counties and cities opting out or the smaller ones. I could imagine Hennepin saying we want to do this ourselves, but I would just be guessing. I really don't know. But it's an interesting question.
Well, we'll ask the auditor all those questions.
Yeah.
So the Office of the State Treasurer, we didn't talk about that one. That was eliminated. Is that right? Do you know?
Yes. But that used to be in the Constitution.
Yeah. Okay. And so we changed our Constitution and eliminated the Office of the Treasurer.
We did. This is the case. Before that happened, I believe, and I would need to, if I knew this question was coming, I would have brushed up on this more. But so I believe there was a case, I believe the legislature tried to essentially gut the treasurer's office. Mm-hmm. And that's where we get the language of the Supreme Court saying, you can't do that. The treasurer's in the Constitution. You got to keep its core and inherent functions. So then I believe the next step was to say, okay, what if we just take it out of the Constitution? And that's what happened. I don't know the full backstory of what is being termed here a sketchy former treasurer, but just from a legal perspective, yeah.
We had an elected state treasurer who spent a lot of time not in the state, so.
So ultimately, that was a two-step process. The legislature tried to gut it. The Supreme Court said you can't do that. It's in the Constitution. It's no longer in the Constitution.
Okay, so the next question here, is pretty open-ended. Why hasn't more been done to investigate gun violence? I don't know where that would fall within these offices. Is that something that?
Yeah, so I think there are three levels you can look at. And I would say the best place to look, first I'd say, I don't know how much has been or hasn't been done in terms of what they're doing. I would say if you went to Andy Luger, who's the attorney for the state, federal,
In the U.S.
I'd
attorney.
say we're doing a lot. I mean, but that is, I would say, from the way our federalism is set up and our state set up between federal, state, and local, the best place on gun violence would be to see what are the federal prosecutors doing here in Minnesota, getting those guns off the street. So there was once a push, and I'm not an expert on the criminal stuff, but say you can have these crimes of felon in possession of a firearm, and then that can get you right back. And so they make a push to, if they wanted to, emphasize we're going to go after that. That could happen at the state level too, and it would be the county prosecutors who want to say, okay, we want to go after guns, and it would be the federal prosecutor and the county prosecutor that have the authority to really take a larger perspective of prioritizing, because there's a lot of prosecutorial discretion. If they wanted to prioritize prosecuting people with guns in certain situations of potentially violent situations and otherwise criminal situations, those would be the offices that could take the step to get that going.
Next question. So we were talking about local election officials not doing things quite right. And so I'll read this long question. If a local county official is administering the election day work wrong or discriminatorily, how does one stop that in progress? So you get to vote at 10 a.m. and you find something happening that doesn't follow the law. Lawsuits are after the fact. What can somebody do now? Can you call somebody to get an injunction?
Yes, you would need a team of lawyers, and the major parties typically do, on the ground on election day to hit the ground running. So if there is a problem in the polls, you would race to the courts and ask for an emergency injunction in order to address that on election day. That would be the option in the first place if there's something happening on election day where it's a problem. Because right after the fact, it is going to be too late. So if there's a sort of persistent or ongoing problem, that would be an option. You do see that sometimes, particularly reading here to the last question of, can the governor order that locality to stay open later hours if there's a problem? The governor can't, but a court could. So the hours of the polls is set by statute. The governor doesn't have authority to deviate from those hours. But a court could, if you said, okay, if we don't extend the hours, it would be a constitutional violation. Say, for example, you see it happen, there's long lines, there's a problem with the voting machine that delayed things. It is burdening the right to vote. All these administrative problems or whatever's happening adds up to a burden on the right to vote. And court, please keep the polls open an hour or two later in this particular precinct or this particular location. The court could order that.
Well, yeah. So thank you very much for spending some time with us today. Like I said, we will be getting this video out to others. I appreciate you taking time to spend with us and inform us of everything. Any last words?
No, this has been my pleasure. I learned something preparing for this, and glad that there are people interested in this. I love working at the Attorney General's office. I love the work that the state does. So I'm always interested to learn more and when I get a chance to dig into it.
Okay, well, thank you very much. And thank you everybody for attending. So long.